Yeah.
Yes. So, you guys, you have already seen him yesterday. He gave you a good idea about how to read a patent document and how to draft a claim. So today he will be discussing about the general patent prosecution, how you can go ahead with your patent application after you file it. What are the procedures and things at patent office? He will discuss about all these things. So as you have seen yesterday also, if you have any question, you can ask him directly or you can write it in the chat box also. So thank you, Mr. Murali, for joining us today again. And the floor is yours. Thank you, sir.
Okay. Thank you, ma'am. Just let me- Good afternoon, everyone. I think shall we proceed further or shall we wait for some more time?
Sir, I think we should proceed because there is a time limit. Yesterday also some of the students were leaving by 5:15. So I
Okay.
think we should start now.
Okay.
Sir, Purushottam sir is also there. Sir, is that okay? Can we start now?
Yeah, we can start. No problem.
Okay, sir. Good afternoon, sir.
Good afternoon.
Good afternoon, everyone. Let us go straight away to the presentation. Um, most of the slides, whatever today I have collected, you might be knowing, and some of the slides will be overlapping with other topics of this certificate course. But still, because these are a bit important with respect to the context, I will try to tell very minimal about those topics. So naturally, we know what is a patent, and as Sir said yesterday, that for any patent, it should be novel, non-obvious, and then it should have an industrial applicability. We know that. And when you try to divide the patent activities, we can divide our patent activities in this firm majorly into four, or for any company the patent activities can be divided into majorly into four. There might be n number of other activities as well, but if we try to categorize our activities, patent activities, these can be termed as patent analytics, patent prosecution, patent litigation, mergers, licenses, acquisitions, etc. So when it comes to patent analytics, most of the times novel patent services does that, or most of the legal firms or law firms does this patent analytics. As this is more like we will try to understand what is there in the art, and we will try to give the reports as per the requirements of the companies. So most of the times we actually support different companies, research and development teams of different companies. In this, normally searches like landscape studies, invalidation searches, freedom to operate searches, all these searches, or even patent alerts with respect to a technology, all those will be under this patent analytics category. When it comes to landscape, we what we generally do is, before starting any research, sometimes people might want to understand what is there till date. So we do patent landscaping studies, and we'll try to give them reports what is there till date, who are the major players, and what is the technology, and how the technology is trending currently, etc. Will be given in landscaping reports. And another very important thing is clearance reports. Most of the times we know that we will not get a patent, but our market would demand a change in the product. So naturally, as per the market survey we do, the changes we do to our product will be implemented or will be incorporated into our product. And those incorporations, though in India to some extent enforcement of IP is not that much, but in rest of the Western countries and everywhere, since implementation of patent law is very high, or the IP is very high. So what they generally do is, normally as per their product cycle, whenever they need some modifications to the product, existing product, they generally implement those changes as per the market study, and they would see whether those changes would qualify for a patent or not. If they don't get qualified for a patent, what they generally do is they make sure the implementation or the correction or modifications done to the product, those changes whatever they have done will not be infringing others. So clearance search is one of the very important aspects of patent analytics. And normally, invalidation, we will try to invalidate the patent what is already granted. All those will, and when it comes to patent alerts, sometimes people would ask us to do for weekly alert, monthly or quarterly, and they will try to understand what kind of patents are being filed by the competitors, if there are any interesting patents, and we will try to understand even the citation analysis and all these things we do in patent analytics. When it comes to patent prosecution, this is the most common thing, though the term legally it is a very complex and it looks as if very fascinating term, but it actually is nothing but our filing process with the patent office, or the complete journey of a patent application right from filing of an application to the grant will be considered as patent prosecution. Like it even includes the patentability search what we do here in patent services company, whatever we do, it includes that, and preparation of different forms and filing, drafting of a patent application, filing the preparation of different forms and filing that application with the patent office. And when we file a patent application to the patent office, it would examine, and then they would give us different objections from them, and we call them as office actions in US, and we call them as FER in India, first examination report in India. All those reports will be given by patent office, and for that again either the inventor or the attorney or the agent would try to support our application or the support our invention, and based on our arguments, patent examiner or the controller would decide whether to give a patent or not. So till grant, whatever we do with the patent office or whatever we interact with the patent office, all those documents, all those interactions would come under patent prosecution. So naturally, patentability search, patent drafting, patent filing, replying to office actions or office objections raised by the examiner or controller, and argument before the examiner, because after examination report, if he is not satisfied with our arguments, he would ask us to attend for hearing, and once we attend for hearing, and all those arguments we do with examiner would be considered as hearing, and then based on our arguments and everything, he would decide whether to give a patent or not. And that till grant, whatever we do with the patent office will be considered as patent prosecution. And even sometimes post grant and pre grant oppositions will also be there. Those also would come under patent prosecution. And sometimes we need to update inventors, because some will be missed because of while filing due to ignorance or something, some due to any reason, inventors might be missed. Addition of inventors, assigning application to the another company or another firm or another organization, all those activities, whatever we do with the patent office would come under patent prosecution. Next is patent litigation. Patent litigation is something like, it is generally on a broader term, what activities come under patent litigation is whenever we like when we get grant or the any issues which are related to patents, but they are not dealt in patent office, any issues, but it will be dealt in courts. So activities or opposition to the patent or any infringement cases or invalidation cases which go to the patent court, all those activities will be called as litigation. So, and the fourth major activity with respect to the patents will be mergers, acquisitions, licenses. So once we file a patent and once we get a grant for our applications, Normally, either we will be producing our activity or we will be producing our invention and marketing it, or sometimes what we generally do is we will sell our technology to players who are in manufacturing and marketing and sales of different products of different companies, or sometimes those companies would acquire us if we are small, or we can give different kinds of licenses like non-exclusive licenses, exclusive licenses, or we can simply sell the technology to the companies. All those activities post grant, whatever we do, or the working of patent would come under mergers and acquisitions or licenses, or working of the patent in the market will be the major four activities what we generally do with the patents. So, in order to understand different patent prosecution terms, these are some of the salient features of Indian Patent Act. We know that we can protect product as well as patent product, process and product, and the term of patent is 20 years from the date of filing or from the priority date. Examination on request, by default they would not examine. We need to request patent office to examine our application, otherwise they don't do. For that we need to pay some more fees for examination, only then patent office would examine, otherwise it would not examine. And there are provisions for both pre-grant and post-grant oppositions. Pre-grant, that itself tells that any opposition to your patent before the grant will be called as pre-grant. Any opposition after the grant within 12 months from the grant will be considered as post-grant opposition. And further, we will try to discuss a bit more on pre-grant and post-grant opposition later in our presentation. And we have even fast-track mechanisms for patent examination, for grants, publications and everything. And we even have a biodiversity and traditional knowledge bank, because most of the times we might have heard like turmeric, neem, all those patents for yoga, all those our traditional knowledge is being filed in different European or Western countries. So in order to avoid or in order to prevent such kind of patents in those countries, we started our biodiversity or traditional knowledge banks, and publication of applications after 18 months with facility for early publication. Normally when we file for a patent application, it gets published within 18 months, though we don't pay the fees, extra fees for publication. By default it gets published. And if you want it to be published because of your some strategy based on your requirement, there is even a provision for early publication. And because of many amendments to the law and amendments to the rules, now the timelines for grant has reduced significantly. And this is the general process for patent. And normally when you get an unique idea, if you feel that idea is not complete, or you feel that you need to develop more, unless and until I develop more, it will not be standing as a single invention, then you can reserve your priority date. You can file it as a provisional application. Once you file a provisional application, within 12 months from the filing of provisional application, you can file complete specification. Suppose, for example, if you start with provisional applications, within 12 months only, you got to file complete specification, and filing in any other country or in PCT route has to be done within those 12 months only. It's not like once we file a provisional application, we'll have 12 months and from then again 12 months. It's not that. Within this 12 months only, we need to file complete specification as well as the patent applications wherever you want to file. Either it is in any other countries, either through conventional way of filing or through PCT. And once you file a patent complete specification, within 18 months from the date of filing of this, from the priority date, it will be published by default if you don't pay extra fees. If you pay extra fees, it will be published within 1 month from the date of paying your extra fees for expedited early publication. And within 48 months from the priority date, you need to file for request for examination. Only then patent office will examine. Otherwise, it will be considered as abandoned after 48 months if you don't file for request for examination. Once you file for request for examination, normally patent office would have, suppose for example, my invention is in IoT. Maybe patent office might already have 1 lakh applications in IoT, and my now if I file for a request for examination, the application will be 1 lakh 1. My serial number will be 1 lakh 1. So after examining all those 1 lakh applications, there will be a number of patent examiners for each department. For IoT, you have more than 30 or 40 examiners. So naturally, for each department, they have some set of people who would examine our applications. So in serial order, they will come to our number. So based on prior to 2015, it used to take minimum, after we apply for request for examination, it used to take at least 4 years to examine our application. But recently what we are finding is they are even examining within 1 month or 2 months also, depending on the department where we are filing. Like they would decide to which department it would go. Once we file, our application will go to RACS team, where it is a computer section of the patent office. That RACS team, based on our title and abstract, it will decide to which department it would go to, and they would give a classification code to that, and they would assign to that department. Then based on the serial order what they have, it will be in that serial order for examination. So once we file for request for examination, they would examine within the as per the serial order, and they would give us examination objections as FER in India, first examination report they will give. Within 6 months from then, we need to file our supporting arguments to the patent office, stating that in what way our invention would suffice all the requirements as per the patent law, and we need to reply to that. If he is sometimes, if he is not satisfied, he would ask us to come for a one-on-one meeting. Earlier, prior COVID, it used to be majorly it used to be physical one-on-one interviews. Now, after post-COVID, what is happening is we are going only video conference, that is a recorded line, and it will be examined. And all those hearings or arguments from us will be heard through video conference, and based on that, after video conference, within 2 weeks from video conference, we need to submit our written submission to that hearing. Once we submit, he would once again go through our arguments, and based on hearing date, he would take a decision, and he would decide whether it is granted or rejected. Okay, so before grant, we can raise a post grant opposition, pre-grant opposition. After grant, we can raise even a post-grant opposition. Once after grant, normal way is we need to pay annual fee every year till 20 years, and it will, after 20 years, it will expire. This is the general process. Most of you might be knowing it. And as I said earlier, once we apply for examination, you would receive a first examination report from Indian Patent Office. In US, we call them as office action, and this is very important. Based on these objections, we can tell whether we'll get a grant or not, to what extent, what kind of prior art is there, and based on our arguments, the life of your patent will be decided. So this is a general view of first page of your examination report will be. And if you find here, this is an application number. This is one of our application what we got, like what we filed from our company, and in this case we got grant. And to understand that, we would let us go in detail about this first examination report. If you can see this, you can find your application number. Date of filing is September 5th, 2022, and we don't have a priority date, so the same will be the priority date. And because we are not from PCT, that number is not there. And applicant is Aditya, and request for examination is done on it is 9th of September itself. We have requested for examination, and on 9th actually it got published as well. And if you see the examination summary of the report, this would be the scenario, how they generally give. If you see here, first you would find requirements under the Act for any patent, as we discussed earlier. For any patent, these are some of the requirements which we need to get from an application. So requirements will be like, does it have inventive step or novelty? So if you see here, claim numbers 1 to 9, if they write here, if they say yes, if they write in this column, it is that he is accepting that there is an inventive step in the application. And in our case, what happened, claims 1 to 9, no is there in remarks section, which says that examiner feels that there is no inventive step in this application for all the 9 claims. And there is even a report for non-patentability. If you see under section 3, claims 1 to 9 would fall. Like, does it have a non-patentability section in this? Like, would that apply to that patent or not, would be given here. If it is says yes, what subsection of 3 will be applicable to this invention? As per examiner, it says that 3D is applicable, 3F is not applicable, and 3P is applicable. We would try to go even what is 3D, what is 3F, and what is 3P. And what he's trying to say is all claims would fall under these categories. So it will not be allowed for a patentability, or it will not be granted a patent. And as per section 10 of 5 and 10 of 4, naturally definitiveness and scope. Definitiveness means the document, whatever you have submitted, is not clear or clear.
Can you please zoom the slide, sir?
Not sure.
We are not able to see. Thank you.
If you see their definitiveness and scope, what definitiveness means whatever document we have submitted, if is that clear or not. As per the objections given by this examiner, is all claims 1 to 9 doesn't satisfy the definitiveness section, as well as scope is also not clear. These are the objections given by the examiner. And if you see what requirements are required, like you need to file, amend the claims, and you can submit any other arguments, and everything will be given in this 4th section. And once this is given, they would give just a minute. After that, they would give a detailed technical report like this. If you find this application, he says that there are 6 references which are nearer to our application, or 7 applications which are nearer to our application. In what way D1 is nearer to our application, D2, D3, D4, D6, all till D7, in what way it is related to us will be given, and his explanation and his way of perception towards invention will be given in this detailed invention disclosure. So if you go in detail, so let us try to understand. So once we get this report, so let us try to understand. Let us go back to the exact section and try to analyze what exactly is this what is an invention as per the Patent Act. Section 21J defines what is an invention. Invention means a new product or process involving an inventive step and capable of industrial application. That means it should be new, inventive step, and it should be capable of industrial application. What is invention? Like, what is new? New means invention must not be published in India or elsewhere in prior public knowledge or public use within India or elsewhere, claimed before in any specification in India is also considered. And of course, here it is only given as in India, but it should not be there anywhere on the earth. And when it comes to inventive step, a feature of an invention that involves technical advancement as compared to the existing knowledge or have economic significance, or both, and makes the invention not obvious to a person skilled in the art. So here, if you see, they have raised objection with respect to inventive step as well. They did not raise any objection with respect to novelty part of it. They are accepting that invention is novel, but they are saying that it is not inventive, and some of the claims would not qualify for a patent as per section 3. There's a problem with my slides. Just a minute. Yeah. In simple, what is 21J? What is an invention is, and what is 21JA is. It should have. Here we need to understand two things. It should have a technical advancement, or it should have an economic significance. That means sometimes some inventions which are cost effective can also qualify for a patent, though the inventive steps might look obvious to a person who is skilled in the art. But if I say that there is a significant cost advantage of me because of my patent or because of my technology, though it is an obvious thing for a person who is skilled in the art, but I am the first person to use, and I am trying to save a lot of money in making that product. If I say, if we can prove and if we can establish that point, even that would qualify for a patent. So these are the sections of 3, and I think you had a discussion about section 3, so I'll not go through that in detail. And if you see what is section 10 of 4, every complete specification shall fully and particularly describe the invention and its operation or use and method by which it is to be performed. Yesterday we said that we need to describe as much as possible about our invention, and that is given in 10 of 4. And then if you see 10 of 5, only one invention will be allowed. More than one inventions will not be allowed for a single application. So these 2 points yesterday we discussed the same, but still as per section 10 of 4 and 10 of 5, there were objections from the patent office. So we need to answer even those points. Now coming, let us go in detail about these objections. If you see that section 1 of 1 to 9, it is not qualifying, like inventive step is not there. And if you see 1 to 9, 3D, 3F, 3P are there. Objections are there. As per 3D, 3F and 3P, we are not allowed for a patent. Like it is not patentable as per these sections. And definitiveness is not there, and scope of that is not there. Now let us discuss the same invention. I'll try to give you a brief idea of it. Like it is a big patent, but if you see this is a bottle where you would have water on one side, and you have a compartment kind of thing here, and you have a stirrer here, and you can drink your liquid. Whatever you liquid you want can be drunk from this side. Most of the times these are in sports and everything, wherever it is required. This is a smart bottle configuration what we are trying to invent. Suppose in this section we can have all required ingredients like tulsi or any other cardamom or any other kind of ingredients which you feel you want them to be added to your water. Those will be kept in the middle part of it. It has chamber. So those sections, like here we have shown you only 3, but it is not limited to 3. You can have n number of compartments where you can place different ingredients what you think needs to be mixed with your water, and you can place in those. The main advantage of this invention is it's not like what we generally know is during COVID. What happened is many people used to have, we call it as kashayam. We used to mix all those spices, and we used to heat that water, and we used to drink. Most of the people used to drink for to get immunity. So now here it's beforehand itself, they used to mix all the ingredients, and they used to drink all the ingredients, like a solution containing all the ingredients. But here they brought a provision where they will have all the ingredients, or how many number of ingredients they want in middle section. And whenever they want to mix, like suppose for example I want to have a liquid I want to have a beverage with elachi and only tulasi, and not rest of the things like cardamom or cloves or something else. We will not mix those. We will give an instruction to that, and once we give an instruction, it can be combined into the water will be allowed to that compartment, and water will come out of those compartments, and it will come to this stirrer section. And with stirrer, if you want, you can mix that water and drink. And it also has a provision to heat within the chamber itself, like in beverage section you can even have a provision to heat your water or the beverage, whatever you want to heat. So there is a provision also. So based on your requirement, if you want to heat that solution, you can heat it. If you want to stir it, you can stir it, and you can monitor how much concentration is there. Everything is there in this. So this is the invention. If you see, this is the main important aspects of this invention. So this is a bottle, a smart bottle, which will monitor the concentration, and you can even mix all those ingredients to the beverage, whatever you want to have. If you want to prepare health drink of different ingredients, whatever preferred ingredient you want, you can mix it. So there are some pumps, heaters, and flow of water, arrangement of all this is very important. Everything is brought into a simple normal water bottle, and you can have instantaneous and required, or whatever you feel are important, you can mix them. So as I said earlier, he says, if you see the document here, details of documents like D1 is a CN application, D2 is a WIPO application, D3 is a United States application, and D4 is again a China application, D5 is again a PCT application, and D6 is again a US patent. So if you see their publication dates, all are filed before our patent application. We need to check even that. By any means, because of any reason, examiner sometimes might quote application which was filed after us. So we need to observe even that. Even while sending the FER report itself, he would place everything like this, and you can find what is the publication date and priority dates. And if you see what section of the document is related to our claims. If you see here, as per the examiner, he says the whole document is nearer to all claims of 1 to 9. Like if you see all the documents, like if you see the whole document is nearer to our invention. This is what he is saying. He did not quote any single abstract or a single para or a single section of the patent. He is saying that the whole document is nearer to our invention. So if you see as I showed you earlier, these are some of the extracts from those documents which are nearer to our invention. This is what he is trying to quote. And if you try to analyze if you see, this is as per D1, it is a bottle in various shapes with a simple structure which can be used for drinking at ordinary times, containing various juices or drinks. Like for example, it is not preparing any juice, but at the same time you can have more than one kind of juice in that bottle, and you can drink whatever juice you want. But they are not preparing instantaneously, or they are not having any constructional details like compartments or anything like that. They don't have a stirrer, they don't have anything related to our invention, but simply because it can store more than one juice in single tumbler, and user can drink whatever juice he requires. So it is cited by the examiner. And if you see, D2 is a reference related to a vehicle mounted storage device for storing champagne, red wine, milk, or medicines. It is something like a fridge or refrigerator present in any moving object. Like even in some of the cars, you find some refrigerators. How do you place, like without in most of the refrigerators what we have in car, it will be a small box, ice box kind of thing. They will keep a just vent into that, and we will just send the cool air and to maintain the temperature. Here in this case, what he quoted is they will have some stands, they can place different kinds of bottles of different sizes in a proper way without avoiding spillage and everything. And as per D3, if you see, this is related to beverage bottling plant, not just even a single bottle. It's a beverage bottling plant with a liquid beverage material and a method and device for treatment of bottles and containers to be filled. Like how do we clean those bottles and everything is disclosed in D3. And if you go for D4, is related to identifying color of the beer bottle so that appropriate beer is filled into that bottle. So now the system here disclosed in CN will try to identify the kind of bottle they are trying to fill. Based on that, the appropriate beer is filled. Suppose, for example, some different kinds of companies or different kinds of concentrations or something like that. If there is a difference based on the bottle they are trying to fill, it will be refilling it. And if you see the D5, it is a smart bottle. It shows your hydration levels, your work, safety, etc. is shown here. But you don't prepare anything in this. You can fill the energy drink into that bottle, but it doesn't prepare anything. But it has a provision to just fill. You can monitor your hydration levels and everything. This is a smart bottle, but it doesn't have any preparation kind of thing like what we have in our application. And if you see D6, it is related to preparing simple beverages like milk-based beverages, carbonated drinks, fruit juices, etc. But the construction is totally different, and you don't have any compartment kind of thing. And it is, of course, it is used for preparing beverages, but heaters and everything is not present in D6. So conclusion for inventive step is our construction of our invention is different. We can make instantaneous beverage with required ingredients, with required concentrations. We have a provision to mix, we have a provision to heat, we have a provision to monitor our concentration. Everything is there, but all those things all those features are not there in a single application cited by the examiner. So there is a technical advancement as per our invention. So these are some of the lines on what we have defended our invention. And objections for non-patentability, as I said earlier, 3D, 3F and 3P. He would be quoting like this. Claims 9 fall within the scope of section 3D of the Patents Act 1970 as they relate to the mere use of the known substance and mere use of the known method, thus falling because of section 3 of Patent Act. Therefore, claims are not allowable under section 3D of the Patents Act. So here, I think you might have heard about 3D. So any known substance for using the same known substance and for the same kind of use, it will not be allowed. And most of our people know, like when we use tulasi or ginger or any other cardamom and everything, when we heat, we would get some medicinal impact on the water, and those can be used as medicament for drinking, or it is something like nutritional drink kind of beverage, nutritional beverage. So what he's trying to say is, based on this, all these are known things, and heaters and everything is a known thing. So it is a mere use of a known substance, so it cannot be given a patent. This is about 3D. And when it comes to 3F, these two are interrelated. What he is trying to say is dividing into compartments, using a stirrer, using a monitor to show the concentration of it, and sending water, a bottle. All these things are known substance. You just rearranged everything into a single bottle, and you are trying to claim a invention. This is what he is trying to tell us about this invention. And when you see the third part of it, he's saying that all those ginger, tulasi, all those things are known things. All those would come under traditional knowledge, and we know the medicament or medicinal values of those things. So based on that, we will not be allowing your application. So these are the three aspects on which they have objected in this non-patentability section. We discussed about this, and if you see this in detail about 3D, salts, esters, ethers, polymorphs, Yesterday we discussed about this, what is not allowed as per 3D. But what you can do is, if all these things can be patentable, or derivatives of a known substance with enhanced efficacy are patentable. If I say that simply usage of salts and everything would not, like only composition change but the same efficiency, if I say, I'll not get a patent. But if I say that there is enhanced efficacy, and there is a possibility of getting a patent. So this is an exception for section 3D. And we discussed about this as well. Aspirin is used for normally for headache, and sometimes if I say that new use for heart ailments, etc., if I use, I might get a patent. But here in India, you will not be given a patent for new use. In US, etc., you might get a chance to get a patent if it is not disclosed before. And if you see 3F, you can understand the objection. What is that? Suppose, for example, we know a bucket is used for carrying water, and we know torch for only to show the path. And if you just simply combine these two, you will not be given a patent as per section 3F. And if you say that there is an umbrella to protect you from sun or rain, and if you fit a fan to that, you'll not be given a patent, because fan as an individual, it would stand as a separate product, and umbrella as an individual would stand as a separate product. So those two would stand separately, function independently. If they function independently, you will not be given a patent. But if I say that, suppose, for example, when an umbrella is used for protecting myself from sun, and if I am suffocating from sun, and if I am sweating, and based on that, if it detects automatically, and if my fan switches on based on my requirement, then it might qualify for a patent. Or if you simply say that there is an umbrella and I would fix even fan, so two activities will be done, you will not be given a patent. But if I say that if I fix these two, I would have three activities, or there will be a synergy in it. If I can prove that, if I can show that, I will get a patent. So this is about 3F. And 3P we all know. As per our traditional knowledge, some of the examples is haldi is used for some bacterial treatment of wounds, or for fungus we use neem, etc. All these come under our traditional knowledge. If I use those things, I will not be given a patent. And now if you see our objections, how do we try to support ourselves is the cited documents fail to discuss. No document in this invention, all the 6 documents did not cite anything related to these healthy kind of things, is first point what we try to. There are other things also. Some of the things what we try to defend from our side is a combination of 2 or more ingredients instantaneously, or at the same time instantaneously, as per the requirement, is not found in any of the references there. There is a pre-mixed beverage, and there is there are, as per the quoted references, there is a pre-mixed thing, and there are single beverage kind of thing and everything. But you don't have multi-chamber kind of thing, where you can have you can mix instantaneously, and you can have a beverage of 2 ingredients or 3 ingredients, or you can heat it, or you can stir it. All those things are not there in these things. So this is one of the thing what we try to support from our side. And it is not just mere use of these things, but we are trying to club all those things, and we are trying to get a synergy out of it. Suppose, for example, for me, breathing is a problem. I can use tulasi, and I feel like oxidation or something is more important for me. Anything related to those ingredients, I would try to mix based on requirement. That is not there in the cited documents. And if you see 3F, in the same, you don't have chambers kind of thing, and 3 different sections. That construction is not there, and it is not just a pre-arrangement of thing. We are trying to club all those things for a particular purpose and for a particular function. We are trying to club them, and we are trying to achieve that goal of instantaneous beverage for as per our requirement or as per our desire. This is another point what we respond from our side. And with respect to 3P, we clearly stated that this is not a patent for cardamom or ginger or pepper or the functionality of those ingredients. This is a patent for it is a patent on construction of that bottle. How do we use those ingredients? How do we heat those ingredients? How do we mix those ingredients? How do we make the fresh water to flow from one side to another side? And how are we allowing that? And how are we trying to mix? And how we are trying to attain efficacy out of that mixing? And how are we trying to, because some ingredients we need to heat it for longer period of time, some ingredients we don't want that, some ingredients like that, and for my as per my requirement I need to change. All those changes can be attained with that, but we are not trying to claim anything related medicament properties of those ingredients. So we don't fall under this traditional knowledge section of this patent. So if you see, you can find in the patent database itself, like it is filed on September 5th, 2022, and we got our FER on 19th October 2022. You can see that. I'll try to zoom. We got FER on 19th, and we replied to that with some other modified forms on 7th of April, and by June 8th we could get our grant. 2023 we could get the grant for the patent. This is what simple FER application will be, and if you can track your application in patent office database. Like you can find all the documents what we have submitted, and we can analyze what kind of suppose if we are trying to monitor our competitors' patents, or if we are trying to understand what our competitor is doing and how did the prosecution go. Sometimes in litigations and everything, we need to understand how exactly the prosecution went with the patent office, and what kind of objections were raised with the patent office, and what were the answers given by the inventor or the patent agent. All those can be monitored using this data from the patent office database. It is freely available and anyone can monitor it. And to understand, now we have seen the flow of patents in Indian Patent Office. Yesterday we discussed in detail about this PCT application. If you see, there are two ways of filing. One is traditional or conventional filing system, where from the date of filing, within 12 months, you got to file in all those countries wherever you want to file. And sometimes, so naturally, you will have additional fees, local agents fees, everything, government fees of each country, everything you need to attain within these 12 months, and you need to decide to which country you want to go. But here, what advantage you have is you have minimum of 30 months. For some countries, you even have 31 months. So once you file your application in the national phase application, either in India or in any other country, within 12 months from there, you got to file PCT application. This is what is shown here. And from there, they'll issue a search report within 16 months. Like the fees, whatever we file for pay for PCT application includes this search report fees. We need to pay International Search Authority. Like we need to select which search authority you want your application to be examined. There are 8 countries where you can select which country you want your application to be examined. So, and even India is one of the International Search Authority. So you can even opt Indian Patent Office also for searching your application. This is a must and mandatory step for any PCT application. But when you go for an examination of your application, it is an optional thing. If you pay extra fees for it, they would examine before entering into 30 months. They would examine and they would give you an opinion whether there are patentability chances or not within 20 to 28 months. So these two are optional steps, but this is a mandatory step. 16th is a mandatory step. So within those 30 months, if you want to, based on this result, If you want to decide whether to go into you need to pay additional fees and get it examined, and then go for all those countries wherever you want to do. Again, the same, all those steps what we have seen in the conventional filing, all the steps we need to do for each country here. But only difference is we will have 30 months here, we don't have 30 months here. That's the only difference. And if you see, this is a unified application process. There is an international application, but there is no grant. International grant is not there. There is only a international application, that is, and it will be the application will start from WO. It is because it is an WIPO application. The number of that application would start from WO, and you will have international search authorities somewhere around 7 to 8 countries are there. I'm not sure exactly what 7 or 8, but even India is also one of the authority which can give search for your application and see what are the nearby applications to your application, and based on those you can decide if you want to go ahead or not. As I told you earlier, preliminary examination is also a optional thing. If you want, you can do it. Once that is done, you can go for a national phase application. Whichever country you feel you are interested to file, you can do it. And when it comes to opposition, if you are not, suppose for example, you are not the owner of the application, but if you feel that someone is getting the patent wrongfully, or due to some reason you don't want that application to be granted to your to the inventor, there is a provision in Patent Office or Patent Act. Those are pre-grant oppositions and post-grant oppositions. As per section 25 of 1 is pre-grant opposition, and as per section 25 of, when we say pre-grant, the name itself tells that before grant, whatever before the decision made by the examiner or the controller, if you file an opposition, it will be considered as a pre-grant opposition, and if it is filed after grant, it will be considered as post-grant. There are some rules, grounds for opposition. These are some of the rules. Like invention has been published before the priority date, and you feel that it is wrongfully obtained, or it is an obvious thing. Sometimes examiner by mistake, look, he might feel he might have granted all those. These are some of the conditions where based on which you can oppose. Other than this, you cannot go for opposition. Only based on these conditions only. If something falls under these, only then you can go for a post grant opposition or pre grant opposition. Normally pre-grant opposition is allowed. Anyone can file a pre-grant opposition. Suppose for example, if I am an inventor and if I file an application, suppose you feel not get a patent grant, you can also, though you are not working in the field and you are not the interested party, like anyone, not only interested parties, anyone can file. But when they say interested party, normally is people who are working in that area, or some way or the other they are related to that invention, will be considered as interested parties. In pre-grant oppositions, any general public can oppose the grant of the patent, but in post-grant oppositions it is not allowed. Like you will be if you are an interested party, if suppose you are an inventor but you are excluded from that invention, so then you can go for a post-grant opposition. Or you are making a product which is related to that invention. That means in pre-grant opposition anyone can go, but in post-grant opposition only people who are in that area, who are working in that area, will only be allowed for post-grant opposition. So nationally time limit here we have seen here is 6 months, but before grant we can file a post-grant opposition, a pre-grant opposition. And once we file a opposition, normally what would happen is patent office would form a board where at least 2 or 3 people will be forming a thing, and will be an in charge of that post-grant opposition, pre-grant or post-grant opposition. They will form a board and they will call for like arguments, like on what basis, like suppose for example someone has raised a pre-grant opposition, they will communicate, patent office will communicate that pre-grant opposition to the inventor, stating that you submit your arguments against to that pre-grant opposition, and they will give us a date, and he would hear our arguments from both the sides, right from person who is opposing your invention as well as from the inventor. Based on the arguments, he would ask both of them to submit your arguments, written submission of those arguments, and based on that he will take a decision whether to allow that pre-grant opposition or not, or to abandon the pre-grant opposition. He will take a decision to reject the pre-grant opposition. He would take a decision. As we discussed, we need to raise the post-grant opposition within 18 months, but generally it is 12 months only. Maximum is 18 months. Within 18 months from the date of grant, we need to raise opposition. As I said earlier, only interested parties can raise an opposition. That means if he is an inventor or if he is an applicant, he involved in research, or a company which is into that product making, which is working on that product, only those people are allowed to raise post-grant oppositions. Otherwise, people are not allowed. These both the pre-grant oppositions and post-grant oppositions are generally done at a patent office level, and it is not at court level. So all these would come under prosecution only. That's it. Initiation, the same thing, same examination board will be done. They would ask for arguments, and sometimes they make a decision on it. They might allow us to amend the application. All those are the provisions which we can get from post-grant oppositions. That's it from my side. If you have any doubts, you can please ask me.
See, my dear participants, already has given a broad overview of the prosecution. You know, as I said, prosecution means Hello. Hello.
Sir, now you are clear, sir.
Yeah. See, it is a techno-legal perspective of patent granting process. You know, whatever happens, the entire from the date of your submission of your application till the grant of your either grant or rejection, you know, what are all actions happens in the patent office, that is actually the jurisdiction for the patent prosecution per se. No? What are all the actions, or what are all the replies, what are all the interactions happens, you know, which are all techno-legal related aspects, and they all happen in the Indian Patent Office, which grants the rights on our patents, you know. So all the things happens in the Indian Patent Office. We can call it as a prosecution, you know, prosecution of patent prosecution. So it's very important cog in the wheel of getting your patent rights, you know. This is authority grants the rights to the individuals or the inventors who apply for the patent. Is also nicely explained on what grounds the patent office examines your invention. The three pillars of examination is the novelty, inventive step, and industrial application. So every inventor supposed to do that kind of a preliminary analysis by yourself or through your patent agent before you submit your application to the patent office, because they also do the same kind of analysis, and this is such a transparent process, you know. They've already defined on what parameters they prosecute your application. So you can also do on your own with the help of your patent agent, the same kind of analysis before submitting or before drafting your patent application, so that both the places we are using the same kind of a transparent mechanism of evaluation basically. And if you know in advance how they analyze, you can also do and satisfy yourselves. And if there are any gaps, and if there are any mismatches, and if you are not able to find your invention is not having a meeting that kind of a criteria of novelty, inventive step, industrial use, you can always modify and do additional research to overcome such kind of a gaps, before submitting your application. And it's a wonderful talk. I really appreciate Murali for explaining so nicely the basic concepts about, the patent prosecution. So what are all things happens from the date of submission of your application until whether the rights are granted or rejected, all the actions are covered under the patent prosecution, as I understand from Murali's talk, So if you have
Yes.
any good questions, please raise your doubts and seek clarifications. Because Mr. Murali has prosecuted, I think, by now about 1,000 patent applications you have crossed, or more?
Yes, sir. Yes, sir. More than 1,000, sir.
More than, 2,000.
No, sir. Somewhere around 1,500, sir.
1,500.
Indian Patent Office.
Indian Patent Office. So this is a great milestone for their office, for their staff, and for novel patents. So each patent is a unique in its sense, Got any innovative ideas where you have doubts, you can also seek clarification from Murali. Any questions, Anandya, in the chat box? If you have any questions, please take up those questions. Friends, open up and raise questions. This is a wonderful topic, and you will get a lot of doubts, the timelines, the fees. Suppose somebody objects your application, how you should respond. You should get so many doubts. This is such a wonderful topic he has covered. Not able to hear you. Not able to hear your voice is not clear. No problem.
You are not properly audible initially. If you have any question, you can please drop it in the chat box.
Sir, good evening. Ravindra Prasad here.
Yes, sir. Yes, sir.
Yeah.
Please.
I have just basic three doubts here
Yes.
regarding to the objections from the patent office. See, once the patent office send an objections to grant exclusive right or the patent. See, so we have responded to that objection, and
Yes.
that is the clear part. And suppose as a counterpart, I have raised an objection for the previously granted patent. So for
Yes.
that, do I need to make any fees?
Yes, sir. To raise pre-grant or post-grant oppositions, we need to pay fees, sir. Only then they will allow. And now you, as per your question, you said that after grant you want to raise.
Yes.
As I said earlier, you should be interested party. Only then you will be allowed to raise a post-grant opposition. For that, you need to pay even fees, sir. If it is an individual, some fees will be somewhere around 8,000. And if it is in a company, it is even more than that.
Okay. Even in the case of a pre-grant objection?
In pre-grant opposition, anyone can raise, as I said earlier. And the fees will be there, but minimal, sir.
Minimal. Okay. If in my argument, if I succeeded to get a patent, so to get cancelled for the earlier one, so
Yes.
will they? What about the payment fees and everything paid from the first party, the inventor?
No, this is not a litigation, sir. Court will only give those things, sir. Like they will allow, they actually give money back, and they will try to compensate you. But as long as you do with patent office, it is that they would allow that patent, they will not allow that patent, they would amend that patent, they will not amend that patent. So only those actions will be there with the patent office, sir.
Yeah, I say as the third one is as you said, these obligations and objections are at the patent office level,
Yes, sir.
right? If this is the same obligation or an objection at the patent office level is not yet mitigated at the particular time, will you go for any appeal for another higher authority?
Normally, there's in patent office, what we observed, sir, sometimes what will happen for normal forms during, like for example, this year only, after June end, July to till now, there was an organizational change within the patent office. They're updating their software. They have transferred their offices from one place to another. Because of that, there were some procedural delays for that. But it is like what will happen is, what we observed is, for normal forms they might take lot of time to respond, but for petitions and oppositions, generally they would must and should they would respond to your application, and they would actually form, and they would take some kind of action to your petitions and oppositions, sir. But only thing is, because of some organizational changes and everything, it might get delayed, but normally these will be on priority and they will respond to those, sir.
Timelines, you cannot oppose, I think after 1 year of grant,
Yes,
only within 1 year of the grant only one can oppose.
yes, sir.
Not beyond.
Yes, sir.
And the same way, if you also can explain the definition of interested party, I think that is important for the participants to understand whether you are an interested party or not. Suppose if you want to oppose some granted patent within that 1 year period, as Murali says, everyone cannot grant, anyone can oppose, but post grant only interested party. So as per the Indian Patent Act, what is the definition of an interested party?
Any inventor who actually contributed, but due to some reason he was omitted, or any inventor who is part of that invention can also do, or a person who contributed, or the assignees, all those are one section, sir. And another section is people who are working on same kind of products. Suppose, for example, mine invention is on laptop, and someone like Lenovo or IBM will qualify as a Dell. All those people would qualify if I am manufacturing, if they are into manufacturing of those laptops, and if they are working on those parts, they are eligible, or they will be considered as interested parties, sir. So there are two kinds. Like, one is people who contributed to the invention will also qualify for as a interested party, and commercially who are actually practicing on that product or who are into that business would also qualify for post grant opposition, sir. They will be considered as interested parties.
Yeah, great, Murali garu. Just actually, I have some very much confusion here after Purushottam sir has given as a hint to that. I thought of that interested party here is the applicant of the patent applicant. Usually there is one or assignee. So either these two persons only eligible to
Oppose.
go for application. I thought. Now you cleared it. So
Yes.
who are the interested parties? Who comes under this interested parties? Great.
Yes, thank you, sir.
Anyone else?
There is a question in the chat box. Hina Shilly was trying to talk. She was asking about who is the competent court authority to this.
Patent cases.
So district court is the initial court, ma'am. District court we can initially go, but most of the times we can cross that and we can directly go to high court.
And also, I think, hello.
You are not audible, Hina. You can write in the chat box.
Yeah. Mr. Ravindra Prasad was also asking, I think, if I am understood correctly, who will be the appellate authority in case if he is not satisfied with the decision of the controller in disposing the petition of what
Yes.
you
For the appeal.
Yes,
the
sir.
appeal.
Yeah, earlier there used to be appellate boards, sir. Now actually there were no appellate boards. We can directly go to court only, sir.
if you are not satisfied, if you are aggrieved with the decision of the controller,
We can go to court.
go appeal against that order or a grant or non-grant whatever way, the appellate authority is now High Court.
Yes, sir. High Court.
So in that case, will the patent office and the prior inventor will be the counterparts, or the only
Yes,
two
sir.
parts?
Yes, sir. Both will be there, sir.
So the same thing in the same case, if we apply for the international obligation for the another territories, in that case, what happens? So if in India, just I understand there's a legal hierarchy and the application. If it is happens in the territorial, other than this our India.
Actually, we did not come across anything related to that, sir. Only in two cases, it is like we did not have anything like opposition or something like that. But they are not satisfied with our final arguments. Like in US, you have two kinds of objections from them. One is non-final action, and the other one will be final action. And we will reply to those final actions. If they are not satisfied, they will actually reject our application. Then what we can do is we can file an RCE again and request for examination again. So again they would examine and we need to support in why do they need to re-examine my application. But this post-grant and pre-grant oppositions, right now I don't have the clear-cut idea on other countries, in other countries.
I think Murali, just I would like to supplement here. See, the classical case of neem and turmeric,
Yes,
the
sir. We
patent
want to
was
quote.
granted in America,
Yes,
and
sir.
we wanted to oppose. Where did we oppose? We opposed in the American court only.
Yes,
So
sir.
wherever the patent is granted, whichever jurisdiction, I think we need to protest and file our opposition in that country only.
Yes, sir.
It's
And
not,
there is
the
and
commercial-
there is an yes, sir. There is an arrangement even with WIPO, sir. If suppose, for example, some laws made by some country is not as per the TRIPS agreement or in the direction of TRIPS agreement or GATT agreement, there is an arrangement even with WIPO where they would form a board and where people from different countries would form a board and they can resolve the issues there also, sir. There is an arrangement with WIPO as well.
Yeah. So that is what that cases I was closely observing those days, the turmeric and neem,
Yes, sir.
for which India fought, but we fought those cases in the American courts only.
Yes, sir.
So that's why it costed a huge lot of money for India. Ultimately, we won those cases and those patents were cancelled or revoked because of our opposition, post-grant opposition. Anything
there
else?
is a request in the chat box to Murli sir about the PPTs, yesterday's and today's PPTs, because she is saying it's difficult to remember everything.
Yeah, I think you will share, no issue. There are general issues only, general content.
General content I'll share, sir. Only one or two. If there is anything to be removed, I'll remove and
Yeah,
share.
yeah, you can do that, no problem. No issue. Yeah, anything else? If there are people again, I don't know why you have suddenly become dull. You should bombard with questions.
Our exam is on 26th, so if Murli sir can provide the PPTs earlier, then it will be helpful for the participants.
Yeah.
Sure, ma'am. I'll send it.
Thank you, sir.
What some question is there in the chat box?
Yes, sir.
Gade. What is
The
that?
difference
One
between
is the difference between filing date and priority date, sir, from
Yes.
Ram Nishant.
Yeah. That is also a good question. Yeah.
Yes, sir. When we say filing date, the complete specification date will be a filing date or the provisional application date. If I file an application, first if you consider my application to be filed on January 1st, and there are two scenarios here. One is first we'll file a provisional application and then complete specification. And the other route is first I'll file a complete specification, then file another patent of addition to the existing application. Only in those cases, priority dates and filing dates differ. If I directly file a complete specification without filing provisional application, my filing date will be the same priority date.
Yeah.
But when it comes to when I start with provisional application, and then if I file a complete specification, filing date of my complete specification is the date on which I filed my complete specification, and provisional date will be my priority date. And sometimes when if I start my application with complete specification and then go for a patent of edition or a divisional application, then what will happen? My complete specification date will be my priority date. Patent of edition application date will be different. And again, one more scenario will be there in a divisional application case, where we file unknowingly, we might file two inventions in a single application. During prosecution, patent examiner would advise us to break it into two applications. There again, the application date for the second application will be different for the divisional application, but the priority date will be again the first application date. So priority date is something which we filed earlier, and application dates will be different as per how we file. And there is another scenario where you would lose even your priority date. Sometimes what would happen, I would file a provisional application. Within 12 months, I need to file a complete specifications. My research will not be completed. Then there is a provision in Patent Office, Patent Act, where we can post date my application. Like I can lose my priority date. I can postpone my priority date by 6 months, at least by 6 months.
Ram Nishant, congratulations to you. You have asked the very basic, fundamental, and the best question I could see so far. Even people like us who have been working in this area, I got a doubt this one recently, and I got it clarified, by reading and talking to experts in that area. This is a wonderful, basic, fundamental question. We all should know what is the difference between a priority date and filing date. Filing date. So this is very, very important. All the people who would like to file patents, they should know. So priority date will be there, as Murali says, if you are filing a provisional application. So from that date onwards, you get priority for your invention. That is why the priority date and filing date. So initially you have filed, after 12 months you can file the complete specification. That is a filing date for the complete specification, and you get priority for that invention from the date of your provisional application, precisely. Am I right, Murali?
Yes, sir.
For my understanding, yeah. So that is very, very important question. Like that, people should open up their minds, understand the basics. We don't expect you to become experts, but at least your concept should be very clear after attending this class. And I think there are a few more questions.
One question is, if grant is rejected after FER, can he ask for reconsideration?
After FER, they will give one more notice, ma'am. That is a hearing notice. Here again, we will try to talk with patent examiner, and we will try to convince. If he doesn't, then after hearing also, we will try to submit a hearing submission, like written submission to the hearing. And sometimes he will not accept. Then we can, within 3 months, we can request the patent office to reconsider my application, and we can ask for re-examination within 3 months. But the problem here is the same application will go to the same examiner. It's not to any other examiner. So again, he will try to defend on his own grounds. So instead of going to the same examiner, it is always advisable to go to court. But there is a provision in Patent Office or Patent Act where you can oppose the decision taken by the controller and ask him for re-examination.
There are one or two more good questions. Surabhi Anand. That's a good question. You can read out that, Anandya.
Yes, the question is, to post VCT application, I have 12 months of time to apply in other countries for the same patent. If someone else files before I do, within that 12 months, how it will be settled?
As long as we follow these timelines, our priority date will be reserved for us. So whenever we file our application in India and then go for PCT, our application date in India will be considered as priority date for that application. Though PCT application date is after 12 months, but my priority date will be Indian patent application filing date. Here again, you can find how exactly priority date would come. And again, after 30 months, if you file in US, the filing date for US application will be the date of 30th month, but priority date will be Indian filing date. So priority will be maintained as long as we follow these timelines. If we abide to these timelines, if we don't follow or abide to these timelines, in some countries we can pay extra fees and go into the patent office. I mean, file our application up to 2 months. So even US would allow 1 year, almost 1 year, but you need to pay a huge amount of fees for it. But normally it will be abandoned, or sometimes your application itself would be cited as prior art.
It's already published.
Yes, sir. Would be as published, or it would be cited as prior art by the examiner.
Yeah. So there are so many good questions. After listening to him, I am getting doubts. You people also should get that kind of a doubts. See here, what Surabhi has raised, there also you will find, the importance of priority date. So in international applications also, again, there will be the priority date and filing date. These are the two dates. You should know the difference.
Yes, sir.
It's a very important concept.
And 3 dates will be there, sir. One is priority date, filing date or application date, and publication date. And in publication also, there will be 2 publications. One is application publication and the other is grant publication.
Okay. So all these things are sometimes very confusing, but unless you go in depth and talk to experts, those doubts is very difficult to get clarified.
So there is another question: why should examiner be requested for examining the application?
Yeah,
I
good
think
question.
he is asking why we have to request, why the examination is not automatic.
Good question.
Actually, this is a law, and there is nothing like there is no analogy, madam. Most of the times, what would happen is, unless and until you request for examination, they actually don't do it. And some companies, as their strategy, sometimes they go for a patent application, but after some time, 1 or 2 years, they might feel that your application is not good. So you can by yourself stop paying fees, and you can just simply avoid examination and just simply get it abandoned by itself. Or even you can file a form stating that abandon my application. All those provisions are there, but there is no something like why we should request. But this is the process set up defined by the patent office.
I think there is some terminology for this, that this because we adopted this examination process. I think in the patent law there is some kind of a word for this. The patent offices across the world, they examine only after we file our request for examination. Otherwise, they don't do it on their own.
Yes.
This is one of the mandatory requirement in the entire prosecution of patents. I forgot the terminology, specific word, but there is a specific word for this. We have all chosen that method.
Yes.
The basic logic might be like we have to pay the fees for request for examination. Until you pay the fee, your application cannot be examined. That is the logic behind that.
So what is the significance of application of application? This is also a good question. Last question you can see on the screen.
Obligation of application.
What is the significance of publication of an application?
Normally, publish your application 2 times. One is when your application is applied after 18 months, or once you pay the early publication fees, it will be published to the public domain, and people who want to oppose can oppose, or people who want to understand your technology, they can understand. They can do whatever they want, and sometimes inventor or the applicant himself would use their for their business strategies, like they can show it to their required concerned people like investors or someone like that. So based on their strategy, they can decide. So as an application, once they will publish, as a grant, they will publish. And normally in patent analytics, what we generally do is, once we see the application publications, we can know the recent trends of technology, what is being applied or what is being done in that technology, we can observe there. So after 18 months, it will come to the public domain. Till 18 months, it will generally be in under secrecy directions. So it will not be published.
Good question, Ramnishant, again. Very basic question, See, as far as I would also like to add 1 or 2 points by what is the significance of publication. Once it is published in the patent office journal or a gazette, the entire world comes to know about your invention. That is the only way. Unless it is published, nobody knows about your invention officially, So the significance for publication of your patent application is that the entire world will come to know about your invention officially from the government. So and so has applied for this patent. This is the scope of his invention. After coming to knowing about this invention, if you want to oppose, you can also oppose. But apart from that, in Andhra University, our Honorable Vice Chancellor, in his wisdom and vision, what he did is he has given a weightage for patent applications publication for PhD students. If you want to submit your PhD, most of the universities, what is the mandatory requirement? You should have 2 publications of a Scopus indexed journals. You should publish 2 papers in a Scopus indexed journal if you want to submit your requirement in many of the universities as per the UGC norms. So our Vice Chancellor has gone 1 step ahead. Even if you publish a patent application in the patent office gazette or the journal, I consider equivalent to 2 papers published. 1 patent application, if you are able to publish, that is equivalent to publication of 2 research papers. So you can submit your PhD. So many organizations have got their own significance for publication of your patent application. But of course, unless it is published, you cannot, ask for examination also. Am I right? Murali, am I right? Is it required to be it has to be published before we ask for a examination?
Yes, they follow that procedure, but while filing the application itself, we can file all 3 things, sir.
Without the application being published, without the application being published, you cannot ask for examination. So these are all the several significances are there for publication of your patent application.
Yes.
These are some of my Good question. Another, what is that? Would you like to suggest any book for developing knowledge in IPR? There are so many books. If you Google it, you will come to know.
Yes.
There are so many books. Dr. Prabhuddha Ganguly, who was our chief guest on the first, he has also written several books, and these books are followed as a reference books to teach IP in many universities. Yeah, of course, as our colleagues say, Patent Act is the best book to understand Indian Patent Act. Anything? Any other question? I think Anandya and Ashok, you should select some good questions. People who have asked good questions, you should recognize their spirit of asking good questions, and note down those good questions, and let us give some kind of a encouragement and recognition to promote their spirit of inquiry.
Right.
So please note down some of those good questions.
Sure.
Anything else? Also keep a track. I think time is also over now.
Yes, sir.
What time is your session supposed to end? 3:45. Already we crossed the time. Yeah,
Yes.
10 minutes more. If there are no questions, of course, keep thinking. Then you will get a lot of doubts, a lot of questions will come to your mind. So this is such a difficult process in the entire intellectual property certificate course. Prosecution is the most complex, most involved, and you should know various processes, steps involved in it. See, there are a number of forms, fees, timelines, and authorities, this is a crucial chapter in the entire patenting systems in India, understanding the patenting system. But anyway, if you are not able to come up with the questions today, you can ask during the subsequent classes also. You don't have to ask only questions related to that class. Even the earlier classes also, you can always come back with questions and seek clarifications. Okay, thank you, Murali, for your time again.
Thank you, sir.
Valuable time.
Thank you, sir. Thank you.
Spend these 2 days, 2 hours each.
Yes.
On your patents, you could have earned at least 2 lakhs minimum. Thank you.
Thank you very much, sir.
Yeah, thank you. And we look forward for your continuous support.
Sure, sir. Sure,
Thank you very much.
Thank you very much, sir.
Right.
Thank you, sir.
Yeah. Bye. Anandya, floor is yours to make any housekeeping announcements. You would like to give any break?
Yes, so it's already 4:08. So if we take a break now, then we might not be able to finish at 5:15. So I want the participants to tell me whether we should take 5 minutes break or we should carry on.
Just a 2 minutes break, at least.
5 minutes break?
At least 2 minutes.
Okay, I will give you 5 minutes break. So we will join after 5 minutes.
4:15 we will join. All of you, and the attendance also you can post. You already posted here. And day 1 attendance also you can post, Ananja, because I think.
But it was on auto attendance mode, sir. We already have the attendance sheet.
Okay, that's good then. Somebody posted a question yesterday. You have not filled the Google form for first day attendance. Mr. Bobby, what is your issue? You are raising a hand again and again, but you are not talking. Mr. Bobby.
Good afternoon, sir.
You are raising hand again and again. You want to ask anything? Any doubts? What is the issue?
No, sir, I'm clear, sir.
Okay, good.
I'm clear, sir.
Yeah. I'm seeing on the screen you are raising a hand. That's fine.
Okay, sir. Okay, sir. Nothing, sir.
Yes, Anandya, your 5 minutes over. You can probably start. Yeah, Ashok, you are going to talk?
Yes, sir.
Okay, go ahead. Yeah, friends, Ashok is our IP attorney here and has got rich experience in industry and did his intellectual property courses at WIPO as well as IIT Kharagpur, and has got a rich experience and deep domain knowledge, and is a part of our Center for Intellectual Property Rights. So Mr. Ashok is going to speak on international patent filing, expanding protection across the borders. You all know that, if you want to file international patent filing, there are two routes are available to you. One is Invention route, that is what we call, which you want to file, in one or two countries, you can do the patent filing through conventional route. But if you want to file in more than 2 or 3 countries, the PCT route is the most economical route and time-saving route. So Mr. Ashok is going to explain to all of us about what are the processes, what are the challenges, what we should know about international patent filing processes and the fees, the timelines, the processes, the do's, don'ts. So all these things he is going to explain to all of us. Ashok, please go ahead.
Yeah. Good afternoon, everyone. You guys can see my
Good
slide,
afternoon, sir.
right?
Yeah.
This is Ashok Hemantuputuri. So I am an IP attorney here. So hope you guys had a very good session with Murali Krishna Garu on patent prosecution. So do you guys know who can prosecute your patent? Do you know applicant can prosecute your patent if applicant is a national or one of the applicant is a national? Apart from that, Indian patent attorney can prosecute your application. So anyway, you guys had very good session with patent prosecution, and let's delve into international patent filing. So we have to expand our wings to protect our IP protection across borders. So let's start. So what is the nature of the patent right? So a patent is a territorial right. So the right, basically the right is given by the government. So because you have given the knowledge to the society by specification. In the patent, you might be writing the specification. So with that, government is giving the right. So that's the reason it is called a territorial right, and that right is valid only in India. For example, if you file in India, and it is a granting exclusive rights to applicant. So what are the exclusive right? It is an exclusive right and it is a negative right with the borders of the granting country. There is no global or worldwide patent. So I mean to say, right? Can you hear me?
Oh, yes, sir.
Yes, we are able to hear you. You go ahead.
Okay. There is no global or worldwide patent. I mean to say that right, nobody will give the right worldwide because the right is territorial. You can file the patent by using PCT or by using conventional country in different countries. So it will facilitate how to file your application. But if you want to get a patent right, you have to file in a respective country. That's the reason, that is the meaning of no global or worldwide patent. So the right you should get from the respective territory, some respective country. So because the right is given by the country. Applicant must seek protection in individual countries they wish to secure rights. To obtain a patent in foreign country, applicant must file a patent application in that specific country. So if you want to protect your right in other countries, so either you can choose Paris Convention or PCT, and if those countries belongs to same regional area, then you can go for the regional patent office also. So apart from Paris Convention and PCT, even regional patent office also you can file if your countries, your target countries belongs to specific region. So that is what we're going to discuss. And before we're going to discuss what are the basic doctrine, basic principles we're going to discuss. So the first one is a Paris Convention route. We are saying, right, convention application, that is a Paris Convention route. Actually, this is a broad multilateral treaty. This is the first treaty in the history of intellectual property. So it applies to the industrial property. What do you mean by industrial property? Industrial property means, so it might be a patents or trademarks or industrial design or geographical indication, except copyright, everything is a industrial property. So this treaty is applied to the industrial property only. So, and this Paris Convention is administered by WIPO. WIPO is a World Intellectual Property Organization, which is an administrative agency which will administer so many treaties, something like Paris Convention, and even PCT also administered by WIPO, and Berne Convention, and if it is for trademarks, if it is a Madrid, and if it is for industrial design, it is a Hague Agreement. So like that, so many protocols, international protocols are there. International protocols or treaties are there that is administered by WIPO. And another main job of WIPO is it will spread intellectual property information across the world, and it will promote the innovation. So, and also IP Day celebrations on April 26th, which is celebrated by World Intellectual Property Organization, which is in Geneva. So why we are discussing about Paris Convention? So the basic principles that are enshrined in the Paris Convention. So Paris Convention, established in 1883, offers patent protection over almost 170 member countries. So actually it came into the force in 1884. Key benefits include national treatment and the right to priority within 12 months of the first application to contract state. So now we all are discussing about a right to priority, and somebody asked some question about independence of patents and even national treatment. So because we have these three principles, that's the reason we are freely going through different countries, and we are able to protect our intellectual property rights in different countries across the world by using Paris or PCT or regional patent office. So we are going to discuss these three principles and how your patent is protected by using these three principles. As I told earlier, Paris Convention, which is established in 1883. Before 1883, actually, why this treaty has come into the picture? Before 1883, in the Paris, there is a fair or exhibition on the inventions. So whoever come to the exhibition, they are really scared that their invention might be copied by others. So everybody is not disclosing their patents, thinking that their patent might be copied, and there is no protection for their patents or their inventions. There is no concept of patent that time. So that's how the Paris Convention started, and that's how these principles are this principle came into the picture. So especially national treatment, independence of patents, and right to priority. These principles developed over a period of time. So almost 5 to 6 times this Paris Convention has been modified, and these principles are ancient. Now these principles are there in our Patent Act 1970. So let us discuss what are these principles and how it will be useful if you file your patent in a different country, or vice versa. Somebody else file a patent in your country. What is that we're going to protect by using these principles? These principles are enshrined in our Patent Act, even in others' patent acts as well. Apart from World Intellectual Property Organization, there is another main important organization that is called World Trade Organization. So World Trade Organization, it talks about trade between the countries. So there is an international agreement which is enforced by the World Trade Organization, that is called the TRIPS agreement. So that is the acronym. So TRIPS agreement means trade related aspects of intellectual property rights. So basically, this TRIPS enforce, it will provide a minimum standards for intellectual property protection, which will be enforced by all member countries in WTO. So when it comes to intellectual property, this WIPO and this WTO are very, very important. What WTO, it will enforce TRIPS agreement. So whoever is the members of WTO, almost more than 188 countries are members of the WTO. So all countries are obliged to implement TRIPS, and India is compliant with the TRIPS agreement by 2005. 2005, we inculcated all the minimum standards, because minimum standards that are required for intellectual property, that we inculcated in 2005 Patent Act 1970. So let us remember WIPO and WTO. So when it comes to Paris Convention, the first one is the national treatment. So what is national treatment? So which is enshrined in Article 2 and 3 of the Paris Convention. So national treatment means equal protection and legal remedies against infringement for foreign nationals as well, which will ensure the same level of safeguarding intellectual property rights as provided for own nations. For example, whatever in India, there are so many foreigners are also there. So for them also, actually we are giving the same legal right if they file a patent here, not only patent, any intellectual property, and we will give the same legal remedy as of own nations. So here own nationals means they might be a natural person or there might be a legal entity. It doesn't matter whether they are our country natural person or legal entities. If they are foreigners also, we will be giving the equal protection and equal legal remedy against the infringement. That is called the national treatment. Because this is there, that's the reason our IP also will be protected, whoever is part of the PCT, Paris Convention, because this Paris Convention principle, national treatment principle, is enshrined in our Patent Act through TRIPS agreement. TRIPS will give the minimum standards, so that actually we took this national treatment principle. That's the reason whenever you file your patent in different country, by taking permission, whatever may be, if you want to directly file in a foreign country, so you need to take the permission from our patent office and you will be getting approval within 21 days. Or if you don't want to take permission, you can file in India and don't go for the prosecution, wait for 6 weeks, and you can directly file in a foreign country. So if you file in a foreign country, in that process, whatever I discussed, so you will be giving the national treatment, because TRIPS agreement is complied by all the countries in the world. This national treatment is there. That's the reason you are getting the right as of own nations of the respective countries. It is even applies to nations outside the Paris Convention if domiciled or having industrial or commercial establishment in a member country. For example, in India, there is industry or commercial establishment, or there is a person who is from, let's say, Uganda, member country. So if they have some industrial commercial establishment in our country, and if domicile, here domicile means not strict sense of legal domicile. Domicile means ordinarily resident of India, or temporary or permanent resident of India, but he is a foreign nation. For example, even for non-member also, you will be giving the national treatment, provided industrial or commercial establishment should be there, or that guy, that Uganda or whatever may be, so he should be. So even reciprocity, there is no need of, for example, national treatment does not require reciprocity of protection. What do you mean by reciprocity here? For example, imagine protection term of India is, imagine we are giving more than other country. For example, China is giving only 20 years. Okay, if any China national is there in India, and if you file a patent here, maybe he is a ordinary resident or something like that. If you file a patent here, and there is no obligation. India cannot ask that he also should, Chinese also should give 21 years for Indians who are staying in China. So there is no obligation like that. Okay, if India is giving 21 years for their own nations, if India should give even for reciprocity, you cannot ask China also, if you give for my nations 21 years, then only I will give. So there is no obligation like that. That is what national treatment says. And non-member country national, that's what I discussed in Uganda example. Okay, here domicile means it's something like, he is a normal mere resident or more or less permanent resident. An industrial or commercial establishment, they should have some Uganda or whatever I'm discussing, who is a non-member of the Paris Convention. So industrial or commercial establishment should be there in India, then only you can file a patent. Because the address you're gonna give, for example, whenever you file a patent, imagine you are applicant, or so if the applicant is a national, then you're gonna give your address, which is a local address in India, because you are filing in India. Imagine if it is a foreign entity and there is no national, then they have to hire a patent attorney or patent agent who is having service at address in India. So those are the exceptions, whatever I said, foreigner, if you are a complete foreigner, you have to hire a patent agent or patent attorney who is having service at service address at India. So those are one exception, it is there. So apart from that, if you want to protect IP for even foreign national, even for non-member also, so equal treatment will be given. That means national treatment or fair treatment will be given. So benefits of national treatment, see, it encourages international cooperation in innovation and creativity, facilitate foreign investment by ensuring IP production. If we have similar laws, minimum standard production, we enforce it through TRIPS agreement, right? So that means national treatment are there in our act, and as well as whoever is the member of the TRIPS agreement. Almost more than 180 countries are there which are compliant with the TRIPS agreement. So because every country is compliant with the TRIPS agreement, it is easy for them, they can come and invest in our country, so that they feel that their IPs are protected and they are very safe. That's how the foreign direct investment will come. That's how the GDP will increase. That's the reason this IP is very important. So not only having IP, and this kind of national treatment should be there, then only their IP, they also feel that, they means foreigners, also feel that their IPs are safe and protected, and we can easily trade between the countries, and we can establish and we can invest in our country or in any foreign country, whoever is compliant with the TRIPS agreement, whoever is having a national treatment. It reduces barriers to entry in foreign market. That's what I said just now. So, and coming to the independence of patents, somebody asked a question about independence of patents. See, Article 4 bis of the Paris Convention ensures that independence of patent application. Patent applications are not influenced by decision in other nations. See, this is very important. A similar application, for example, you filed in US or China, where the same invention through PCT or the convention or through regional or whatever may be, a similar application acceptance or refusal. So if that application is rejected in USA, it doesn't mean that whatever the same invention you filed in India, doesn't mean that that application also has to be refusal, or if that is accepted there, it should be accepted here also. There is no condition like that. This is called independence of patents. This is also enshrined in TRIPS, and through that it came to the Patent Act. So this is the reason it does not influence other country decisions if your invention is filed in other country as well. And another one is right to priority. We have been discussing about right to priority, and so many people are having questions about right to priority. So actually, this is actually come from the Paris Convention. So these three principles: right to priority and independence of patent, and this right to priority we're going to discuss. Right to priority is the 12-month window allows applicants to enjoy the right to priority. Actually, this right to priority concept, earlier we faced the problem. That's how through Paris Convention this right to priority has came into the picture, and now in 1883 as well. Now it is in our Patent Act as well. This right to priority will give 12 months window. What is this 12-month window? In this 12 months window, you no need. Earlier, if we don't have this kind of right, So you have to file application at the same time in all the countries, which is very difficult, which is impossible. So that's the reason this right to priority provision has been given through Paris Convention. So during this period, inventors can seek funding for their invention development. Within 12 months, through conventional country, through PCT, you can actually launch your application in a different country. So in that way, you will be having some time. So here it is 12 months means this is the convention, Paris Convention. During this period, inventors can seek funding for their inventions development. Market research can be conducted to assess commercial viability. See, in these 12 months, you can do some market research, whether my product or process can be really needed to be protected in some other country. Any potential is there or not for my product or process. You can assess these things. Applicant can bring out a commercial product without losing priority rights in other countries. So because this right is there, your right is protected. Your right is protected. So you no need to file the same application at the same time. We will discuss about this one in further slides as well. So far, any doubts?
No, sir.
Sir, one thing.
Yeah.
Ashok sir. Sir,
Yeah.
here there are there are member countries and non-member countries out of this 170. Right. So if a patent is applied for this 170 countries, any of the member, will it be applied for the non-member countries? Suppose my invention is applied for a patent in this
non-member. I understood. Non-member country, no, it cannot be protected. So, for example, I am talking about this is a Paris Convention. For example, TRIPS, WTO TRIPS, it is almost 170 or 180 countries are there. If you cannot protect your invention in non-member country,
and to say that
they can violate your right. Still, that is not called as infringement.
There is an exclusive right on my invention in this 170 countries. So can be
no exclusive right you don't have unless that government or that country government gives exclusive right. After prosecution is done, then only you will get the exclusive right.
Yeah, that exclusive right is granted in among all these countries. So I have a patent. Suppose the same can be used in out of this 170, right? So
yes, non-member countries they can use. Yes, they can use because it is not protected there. They can open because it is already published, right? So and specification everything they can see. They can open and they can. If that is a product, they can also create the product and they can sell there because that is a non-member country. But very rare countries, some 10 countries are there, which is not even, there is no point to file in those countries.
Okay.
For example, if you don't forget about non-member country, even if it is a member country, and if your patent is not granted there, even there also, your invention somebody can see and somebody can use that. That is not treated as infringement. Okay. So disadvantage of the Paris Convention. See, what is that? Monopolistic use.
You see, Ashok, just one clarification. Just I want to add here. You see, if your patent is not protected in that member country or non-member country, they can practice it, but they cannot apply for patent. Because when they apply for patent, what happens is the patent office examines for novelty. Novelty means what? It should not be in the public domain. Since you have already got a patent in, novelty is absolute novelty. They see for the novelty in the entire world, not only in their country. That is why it's called absolute novelty. This is a very, very important point to all of you should note. When they do the novelty assessment, they do the novelty assessment across the world, in all countries in the world, where the databases are available, As Ashok says, few countries, they don't have even patent offices. So those countries are living apart, but in all the countries, see whether similar kind of knowledge has been reported anywhere. So obviously, patent was granted in India or other countries. So the application will not be considered for grant of patent because already this is in practice, this is in market, this patent has already been granted. But if they want to practice, though it is a violation, but we don't have any rights to protect it. That is one of the weakness in the existing systems. Am I right, Ashok?
Yeah, if a non-member country, what is the need of filing the patent? Because you can directly use the invention because there is no protection there.
Yeah, there is no protection. That's what they can
So
practice
no
it.
need of searching novelty and all. You can
Yeah.
directly use the patent. I mean invention, whatever the invention you file the patent.
But only
So-
thing is, they can use it, but they can't file a patent. They can't seek protection on the same knowledge or the same product.
No need of seeking the protection because it's all public domain and it is not protected in that country. So everybody can use that and they can market also. They can sell it to their local people inside.
Yeah, that's what.
Yeah. So disadvantage of the Paris Convention is we are running out of time. So monopolistic use of patents by foreigners. I will summarize this slide. So, for example, patent is a monopoly. So actually government is giving an exclusive right and which is a negative right. Through with this monopoly, you can misuse also. Even some foreigners, for example, there is a patent, advanced technology is there, which is there in the US, and he wanted to protect in India also. So he can file a patent here and he can get the patent granted. But if he and the person who is a foreigner, if he is not commercializing in India and he is blocking the imports, so the local people cannot use that. And also you are actually hindering. So these kind of monopolies, because what patent gives right, patent can exclude others from importing as well. So this foreigner can block the imports and this foreigner cannot exploit his right. That means he cannot commercialize. In that case, actually monopoly. Misusing is right. So in that case, there is no checks and balance in the case of Paris Convention. But coming to our Patent Act, we have some provisions, compulsory license, through that you can get some remedies. And apart from this Patent Act, we have so many countries are having, countries have competition law or any antitrust laws are there in, if you take in other countries jurisdiction. So to avoid these monopolies, antitrust laws are there, and as well as coming to our country, competition law also there. So that's the reason you always read intellectual property, because you are getting monopoly doesn't mean that you can misuse it. So there are some antitrust laws are there which will monitor you. So this advantage coming to the Paris Convention. So this is one drawback. Paris Convention does not bother about these things. So that country has to bring the corresponding competition law or whatever name. And main disadvantage with Paris Convention is multiple countries are made. Paris would may seem hiring to separate in all those countries, because you cannot manage more than 4 or 5 countries, which is very difficult to manage more than 5 countries if you want to launch your application in different countries across the world. So next solution is a regional patent protection. So far you guys knows about conventional and PCT, and there is another one version is called regional patent protection. So imagine if you want to launch your applications in a countries which belongs to specific region, for example, European Patent Office, there almost all European countries will be covered. So you no need to go for PCT or conventional. If it is more than 4 or 5, those 4 or 5 countries belong to this region, you can use the regional patent office. So for example, these are the regional patent office, European Patent Office, and African Intellectual Property Organization, Euro-Asian Patent Organization, and African Regional Intellectual Property Organization. These are some example regional patent protection. For example, if you want to launch your application in countries which are related to Africa, which belongs to in a single region, you can use one of this, and you no need to go for filing PCT by paying high fees and all, or you no need to go with a conventional route where you cannot manage more than 4 or 5. So what about pros and cons of regional patent protection? So there are some pros: streamlined application, single application for multiple countries, reduce administrative burden. You no need to file each and every country, that is administrative burden. You can file at a time. Cost effective and harmonization, like uniform patent laws and procedures within the region. At the same time, the disadvantages are rejection in one member country does not affect the entire region, because I told about the independence of the patent. Separate filings may be required. Maintenance fees, some regional office may require payment to national office for maintenance, because some regional offices actually they may enforce you to pay directly to the national office. So which are your designated countries in that specific region. National requirements, applicants may need to comply with specific national requirements. Sometimes, some of the countries need some special requirements. So in that case also, it's a disadvantages. So the next solution is like, patent cooperation treaty. This is administered by the International Bureau of the World Intellectual Property Organization, which is in Geneva. So most of the treaties are administered by WIPO. The PCT route allows applicants to apply for patent protection in almost 153 countries as of now, as of 2023, with a single international application. So here it doesn't give the worldwide patent, something like PCT patent or international patent. You cannot get the patent right, but it will facilitate to launch your applications as if it is filed in each chosen state, whatever the state you have chosen. So it will provide the facilitation only, like you can launch in specific countries in a single shot by using PCT patent. It doesn't give any international right. Right, it won't give, because right is given by the respective government, provided you disclose the knowledge by satisfying specification and by satisfying enable and best mode. So, sir, can you please mute? Sir, can you please mute yourself? So advantage of PCT. So obtaining knowledge on patentability and commercial aspects, because you are having extra 18 months when compared to Paris Convention. So totally 30 months you have since from date of priority. So you have plenty of time to get the knowledge about patentability. Whether, because for example, if you want to launch in Germany, France, and some US or some other countries, okay, in this 30 months, because you secured your priority by filing the PCT application. So you have enough time to assess the patentability, that whether I really want to launch in this country, what are the patentability criteria, whether my product or process will be commercialized, any commercial aspects if I launch in this specific country, everything you will be having enough time. And also you are actually postponing the cost of national or regional filing, translating the patent application. See, this is also needed for convention application also, if you are going for other countries, but actually you are postponing the cost. So because you are having 30 months, paying fees for local agents and all, you are postponing it. In that way, you can see whether I really want to file, and so that I will get the returns if I protect my IP there, because it's a costly affair. Patent is PCT provides applicants with value-added information, and because if you file the PCT application, it doesn't mean that whatever the prosecution is done through PCT, that is actually not binding. I just wanted to emphasize, this is not binding. So this is just like, it gives why you are filing through PCT, what are the PCT steps, all these steps will give. I will discuss what are the PCT steps and all. It will give just value-added information on which they can base their patenting decision. Like, it is for applicant, it will give the best value-added information by following the PCT process. And in the PCT, International Search Report and written opinion of International Search Authority give applicants a high-quality, realistic look at patentability prospects of the invention. So I will discuss this line in the next slide. So here, if you take the PCT, so if you want to file if you want to protect your IP in different countries, you can go for PCT or Paris or regional. So actually you are postponing cost for translations, office fees, and local agents when compared to Paris Convention. And the first application actually you are filing in your local country. For example, you are filing in India. So that is your priority date. So basically Paris or PCT, what it does, it will protect your priority date. That's the reason. If you take the PCT, you are protecting almost PCT is member countries are almost 153. In 153 countries, you protected your priority date. So within 12 months, you can file in a different country. So for that, you can directly go for the WIPO website, World Intellectual Property Organization, or you can file your application receiving office. There are so many receiving offices there. Our India also a receiving office. So you can file your PCT application in WIPO or any receiving office. So if you are a national of the respective country, for example, I am Indian national, so I can file a PCT application directly at Delhi. So I mean online you can file, and within 16 months you can get the international search report and written opinion. So actually you are paying the fees. The fees includes internal search report, international search report, and written opinion. So what the basically they search in international search report, they search for your novelty, I mean prior art. They search if this whatever the invention you filed that is a novel or not. Then all the if it is anticipated in any document in anywhere else in the world, if it is a patent literature or non-patent literature, they will search in entire world whether it is a patent or non-patent literature, and they will give the, and also they will give the written opinion about your invention. So whatever the fees you paid by filing international application at the 12th month, whether it is at WIPO office or at the PCT receiving office. Okay, for example, India is also one receiving office. So basically, you will be covered international search report and written opinion. After that, international publication will happen within 8 days from the priority date. So priority initially you filed in India and you wanted to protect at the 12th month in different countries. So from that date onwards, international publication will happen. So international publication happens, PCT application will be published, as well as international search report and written opinion also will be published as part of the international publication at the 18th month. After that, these are all optional. For example, based on the international search report and written opinion, you feel that I need to modify the claims. You can modify the claims and you can request for supplementary international search as well. Because if that is hitting somebody's novelty, some document novelty, so you can change that and you can you can go request for the supplementary international search also, and also by paying extra fee, and also request for the international preliminary examination as well. So you can examine, for example, you target some Germany, France, some US or some China. So in these 4 countries, what are the chances that this application get prosecuted successfully? That also you can. These are all not binding. This is done by PCT because the respecting country is not doing, but these are all not binding. But this is useful. It gives the information to the applicant. So at the 28th month, you will get a supplementary international search report, or because you modified and you searched like, whether my claims or specification is novel or international preliminary report and patent examination. See, what are the potential countries I wanted to launch there? What are the chances that my patent prosecution will go good or not? And at the 30th month, actually you are entering into the national phase. So there are 2 stages. So 30th month only the real prosecution will start. Whatever in the previous class the prosecution told in India, in the same way that will happen in other countries as well. That will actually start at the 30th month only. There you need to pay the fees for the translation, office fees, and local agents in their respective country. Whatever you filed, whatever you pay the fees for filing PCT application, that only covers international search report and written opinion. If you want to get it done, remaining supplementary or preliminary examination, you have to pay extra. And when you get into 30th month, when you are launching your application in a designated country, here designated means the country which you want to launch. There also you have to pay all the cost, translation, because the respective country might be, if you want to launch in China, so translation is needed in Chinese language. Corresponding office fees of the patent office of the China, and local agent you have to hire. Basically, this PCT is you are just postponing extra 18 months when compared to the Paris Convention. So, and the results which you get it through supplementary international search or preliminary examination, they are not binding, but it gives the, that's what the value added information on which they can base their patenting decision. And also I told about ISR and written opinion that will be published. And ISA, I wanted to talk about ISA. You can select international searching authority. India also one of the international searching authority. So you can select that. Why very less? and international search authority, because Indian Patent Office also international search authority, they will search across all over the world and find out your patent is novel or not, and they will give the search report and written opinion. So give application high quality realistic look at patentable process invention. That is the meaning. Whatever I explained, that is the meaning of this sentence. And pages of PCT international and national. So as I discussed earlier, the international page consists of filing of the international application either with national or regional receiving office or the international bureau of WIPO. So here at the 12th month, actually you can file at the WIPO or you can file at the, so I think, I have to. So at the 12th month, actually you are so filing of the international application either with a national or regional receiving office. So you can file, for example, if it is India, that is a national office, India, you can file there, or you can file at the WIPO, or you can file if you are a member of some regional patent office, where so many countries are there in regional patent office. So at the 12th month, so you can file here. Normally it is online only, or International Bureau of WIPO. So 3 places you can file your PCT application. So novelty search on the patentability of the invention, including an international search report and written opinion and potential patentability. This is what I explained earlier. Publication of both the PCT application and the international search report by WIPO, both will be published. Apart from PCT application, even written opinion also will be published. And request for international preliminary examination of the international application. This is the optional and which is not binding. And what are the advantages? Something like global reach, single application secure priority date in multiple countries. This is the main advantage. So if you are going with the PCT means you secured in 153 countries, which are contracting states of the PCT. International reports, international search and preliminary exam reports aid inventors. I mean aid applicants here. So strategic advantage, publication in international gazette informs stakeholders of the patentee's activities. So cons, that it is a complex formal requirements of different countries needs to be satisfied and high filing fees. And normally PCT route, you are buying extra 18 months. At the same time, it will take long time to grant your patent. So any questions? Hello, are you guys there? Hello, yeah.
Sir, as you said, there is a global reach for single application, right? When there is a company who is spread across many countries, if they are having patents, they have to file in each and every country, right?
Come again, I didn't hear you. I will pay attention to your question. Yeah, please, sir.
Just give me a second. Hello. Global reach, a single application is required.
Okay.
Suppose if a US based company is there and they have got several patents and they are having businesses in across all over maybe a few other countries or more than 100 countries,
right,
then they have to file these patents that they have that they got in US. They have to be validated in each and every country. For
right,
that,
exactly. If they want to protect their invention in those countries as well, okay, they have to protect in respective countries by filing. Anyway, if they have any industrial commercial establishments are there, that means companies are there in those respective countries, they have to, and the invention also relevant to that, they have to protect it. They have.
So is there any like they have to file in each and every country to reach out if they have the commercialization also, so they have to file?
They have to file and get the patent granted in the respective territory. So PCT they can file. Yeah.
Okay.
Without that, your patent, your invention is not protected. Somebody else can use that invention in those countries.
Okay. One more thing is in the example that you have given regarding a foreign national who is practicing invention in suppose in India, he can file, he can approach the Indian government, Indian patent office, and he will get a patent, suppose,
Right,
for example.
right.
If he gets
The
a
way
patent,
we can file a patent in other country. Yes, it's
yeah,
possible.
suppose he files a patent in India
Okay.
and he gets the patent, suppose, and that patent he can use across his nation.
Wherever it is granted, the right is given by the government. Simple. Indian government will give. Indian
Okay.
government right, you cannot show it in other countries, which is not
suppose
valid.
suppose the same example that you have taken from Uganda example,
Right.
where that foreign national belongs to that country but he's practicing in India and got a patent, and he went to Uganda and he cannot use that, right?
He can use it, but there is no protection there.
Okay.
See, if there basically IP is a protection.
Right.
So Uganda is a non-member country. Imagine, okay, non-member country. What is the need of protection? You directly use the patent. No need to protect also. If it is a non-member of Paris Convention, it doesn't matter. You directly use it. So many African countries, they are directly using their invention there. There is no concept of patent and protecting, but very few countries are there.
Thank you.
Okay. And any other questions, please?
Oh, sorry for asking this. I missed the basic concept here.
Okay.
There is a confusion. I need a clarification. So in earlier sessions, what I learned here is that each and every this IPR is a territorial right.
Right.
So we need to apply in each territory. So here, just in your session, I learned it is a single application for all the international territories. So can you elaborate this? I missed some clarification here.
Now, see, actually, IP is a territorial. For example, the right you get is given by the government. See, it's very basic, simple that, why government give a monopoly to you. Monopoly means, like negative right or exclusive right. Why government want to give it to you? Because you are sharing your knowledge to the public. That is the main reason government, to which government is giving, because you are applying in India, so Indian government gives that. So
Correct.
because it's a quid pro quo, you give this information, I give that. What you are giving the knowledge. That's the reason specification. See, for patentability criteria, what are the basic criteria? So novelty, step, and industrial application.
Yes.
Apart from that, you would not fall into non-patentable subject matter, which will change country to country. And also, the main thing is specification. So your invention, while writing, the specification should satisfy some conditions. What is that? Enablement and best mode. Enablement means without undue advantage, somebody should understand. The person who is skilled, you are some computer science engineer, you have come up with some invention. So I am also a computer science, I am an engineer cum lawyer. So I also should be able to understand what are the specification you have written. With that, I should be able to reproduce the invention. In such a way, you need to disclose that. You need to describe the best mode also. Like what is the best possible way that this invention will be, So that kind of information you have to provide as a specification. So because you are giving the knowledge, the specification, that kind of stringent requirement is there in the section 10 of the Patent Act. So that is the reason, government also giving back to you as a right. That is a exclusive right and negative right. You understand, right?
I understand it, but my straightaway point here is the single application for.
Okay. Single application in our country.
Yeah.
Okay.
Single application in our country. No. This is the internationalization. You said it. Single application for other territories.
Yeah, you can file a PCT application international.
With a single
right. You can file a single application. Securing your priority date, which you filed earlier in India. So imagine you filed in India. Okay, after 12 months, you wanted to. Your intention is, I wanted this. My invention is having potential in, for example, Germany and US and China. Okay, I don't want to go for convention because it's very less time, only 12 months only. If I select a PCT, maybe tomorrow, 30th month also, maybe if not these 3 countries, some other countries also I can include. That's the reason I wanted to buy extra time. So let's file a PCT within 12 months. imagine at the 12 months, you are filing a PCT. While filing the PCT, you can designate the states in whichever countries you wanted to launch after 30 months. After 30 months. Okay. After following all the process which I told just now. So basically, you are buying a time compared to the conventional country. But you are filing a single application only. You are securing your priority so that it won't hit your novelty. If you don't secure your priority, so that is available in public domain. Whoever, for example, if you don't file, if there is no concept of securing priority, so if somebody files the same invention in some other country, your own patent invention only become a prior art to that application. So it is avoiding that by securing the priority date. That's how the funda priority. I told, right, 3 principles like national treatment and right to priority and independence of the patent. These 3 are very, very important, which is enshrined in our Patent Act. That's how actually we are filing in a different countries, because these principles are there to protecting foreigners and as well as you. If we are filing in other country, we are a foreigner. If somebody else want to file here, they are the foreigners in our country. Am I making sense?
Yeah, great. Got it.
Any other questions? Please feel free to ask any question. Oh, chat box, some questions are there. Administrator, can you please read out? If you fail to apply in 12 months with full data, what can we do? It's a gone. Your application will be abandoned. But within 12 months, if you don't file your application, so if you are, for example, your provisional application you file within 12 months, if you don't file PCT or something, your priority is not secured and your application will be abandoned as per the Indian Patent Act. For provisional application, how many times can you apply for additional application in the given 12 months? For provisional application, how many times can you? Yeah, additional applications means like, you can, this is called multiple priorities. For example, it's very common that, for example, I have come up with one invention, very good. So I file a patent provisional application. So within 12 months, after 2 or 3 months, I realized that no, this could not be, this could be, some information can be added. So then again, you can file one more provisional specification. So, and you can add, but the priority of that specification is different. And after 3 or 4 months from the second provisional application, again you can file that no, this information also can be added. So you can file a third provisional application as well, provided all these 3 are less than 12 months. So, and finally you file your complete specification. So if you want to draw multiple priorities, because you can draw multiple priorities or partial priorities in a different country. For example, you file 3 provisional specifications and 1 complete specification, and before 12 months are finished, and you file your, because you want to protect the same invention in UK also, imagine. Okay, so you can draw respective priorities from different applications. Hope you understand. Hope I clarified your question. Misala Alekia.
So Ashok, this PCT and PCR both are in practice, right? No? Along with the PCT, the PCR is still in practice.
What is the PC?
The PCT is actually well known for international patent application. So there's still PCR, the Paris.
Yeah, it is practice. It is almost, almost 45% of the application in the world is Paris Convention, and 55 is PCT so far in the world.
Okay.
As per the WIPO, that is what, my LLM is from WIPO. So I did my LLM from WIPO Geneva, and second sem from Ankara University, Turkey, which is in Europe. So I know about WIPO updates very well, and this is the data as far as my knowledge. 45% will file through Paris Convention, and 55 is from PCT. Right.
Good evening, sir.
Yeah, good evening.
I'm a bit confused regarding this PCT because you're saying that when a candidate files for a patent in his home country, he has some 30 odd months for filing a PCT in the member countries.
12 months.
Now, yeah, 12 months. And
So that he will get
once
30 months to file in a foreign country.
so that he can further get 30 months. Now, what's going to happen if he doesn't file a PCT? Because any which ways, if a person from a different country comes with a similar invention, that person's invention will not be patented because of the search and everything, it lacks novelty. So, what will happen if he doesn't file a PCT?
Don't lack the novelty because that is how you are protecting the priority date. Priority date you are protecting means you are protecting your own novelty. That is called right to priority.
I didn't get your point, sir. I'm sorry.
So actually what I'm trying to say is, see, you are saying I filed today, maybe 1 year back, and within 12 months, anyway, after 12 months, anyway, my priority is gone. So what is the point of going for PCT or Paris Convention? Am I right?
No, sir. My question is, what will happen if I don't basically file a PCT? Because I just
wanted to know, why are you going for PCT?
Right.
Come again?
Yes, sir. Yes, my question is, I have filed for a patent in my country.
Right.
Okay. Then, even if I don't go for a PCT, let us suppose I'm not filing a PCT because I'm not interested in marketing in a different country or whatever.
Exactly.
So, what is the difference? Because my invention is any which way is protected because any person from another country can't file a patent on the same invention.
Right, exactly.
So, what is the advantage of filing for a PCT? Unless I'm interested. Unless I'm interested in commercializing in different countries.
Right, exactly. This is for you told the answer already, because so if you don't want to protect in some country, what is the point of filing PCT or Paris Convention? You just file a complete specification within 12 months. That's it. Your patent is granted in your country, and happily you can commercialize your patent. This PCT or Paris Convention, this because this session is about international filing system. If you want to protect it internationally,
no, I just wanted to add something here that if you are not filing in other country, if you are not protecting your invention in other country, anybody can search your application will be publicly available, right? Anybody can search it and they can make it and use it and sell it in that country because you didn't protect your invention in that country.
Exactly.
So if you don't want to lose those money, maybe your invention is so useful that those many countries are using and they are making money out of it, and then you repent that array, I didn't find the application over there. So in those cases, actually, it's useful that you go to other countries. Mostly the MNCs, they will go to PCT because for PCT you can go to several countries. And if you have to file only 1 or 2 countries, choose convention. But if you don't bother about other people copying or using your invention, then don't go. Just be here in India, protect in India only.
Okay, ma'am, I got the point. Thank you. And can you please tell me what's the minimum time frame for getting a patent granted?
It depends upon the patent office. So in India, it is some patents are taking 2 years, some are 4 years. There is no hard and fast rule that your patent will be granted. It depends upon the load of the patent office. So how many patent applications are coming on.
And in the previous session, Murali gave an example saying that earlier, before 2015, it took around 4 years like that. And after 2015, there is a case they have given a patent grant within 2 months also. So based on the other department or the session.
Right. And sir, Ashok sir, you were talking about misusing the patent right. So you were talking about a person, I mean, who has a patent from a different country but stops it being exported or something like that. Can you please explain more?
Monopolistic.
You are muted, sir. Hello, Ashok sir. You are muted. Not audible.
Sorry. So, can you hear me?
Yes, sir.
Yes.
Yes.
For example, if you file a, for example, if some guy who got a patent granted in US and he wanted to protect the same invention in India as well. Okay, so if he file his patent in India and his patent is granted, so he will be also having the monopoly in India for that special invention, whatever the invention he has filed. So with that, what he can do is, what is the right you're gonna get it? If you are a patent holder, what is the right you're gonna get it? The right to exclude others from making, using, selling, offer for sale, and importing. Basically, you can exclude others, because if somebody want to import in this country, because you got a patent in India in this example. So if somebody want to import uh, the similar kind of technology which you patented, so they have to take your permission. So in that way, you are not giving a permission to them, because you can exclude others from importing, as well as you are not commercializing your right, you are not exploiting your right. So in that way, you are actually misusing your monopoly, because that kind of technology you are blocking it, because nobody else can file. Local industries in India cannot come up with invention, file the patent, because already you got a monopoly. And no, if I want to adopt the technology from abroad, you have the right to exclude importation. So how can I get that? For that, there are antitrust laws are there, and even in Patent Act also there are compulsory license and so many other provisions are there. That is what I explained.
So you mean to say that it is like a lose-lose situation where I'm not going to commercialize and neither will I allow anyone else to get hold of the technology?
Import. Yeah. Import. Basically, see, if I don't get the technology, I can import, right, from some other country if I want to use that. Okay, by taking, but because you have patent in India, I need to take permission of you.
Okay.
So basically, that is a clear monopoly. So, but
Right.
Patent Act will balance between the patent holder rights and as well as the society. So these kind of monopolies, Patent Act has some checks and balance where you cannot do like that, because compulsory license might be issued. That means without asking you, government can, without the consent of you, government can issue a license to somebody. Please exploit it, exploit the right. Okay, or else some anti-competitive practice, anti-competition law is there, or antitrust laws are there, where these kind of issues will be addressed.
Okay, sir. Thank you.
Okay, any questions? Hope my session is useful to you guys.
Without a doubt, sir.
Thank you. Okay, and this is filled, right? Attendance sheet is filled, right?
Yeah. Yes.
Okay, Anindya, Dr. Anindya, the floor is yours.
Okay, so if there is no other question, then can you please mute? Venugopal, you can please mute your system. If there is no other question, then we can close the session here. Please mute. Sorry about that. So thank you for joining us today. Tomorrow we will be joining at 2:30 again to have some session on compulsory licensing. Dr. W. N. Dhumane will be with us. for both of the sessions tomorrow. So that's all from us today. See you tomorrow. Bye.